Okay, so you're Jacoby and Dorsey. All right, and was there any additional negotiations?
Just for the record, Judge, I've asked him without talking to Mr. Coleman if he would take the 20 years if it wasn't stacked. He indicated that he wouldn't. Mr. Coleman kind of implied that he may offer that, so I didn't know if you want to change that, but it hasn't really been an offer of that. But
all right, so Mr. Dorsey, it sounds like even if it was a sentence that would run concurrently at the same time as that 30-year sentence that you're serving now, or could be serving if the appeal is affirmed, that you don't want to take any offer or a plea on this.
Right out of the gate, this is huge. The judge is confirming on the record that he's rejecting a deal, even one that would run concurrently with a 30-year sentence. That means no extra time stacked on top. Turning that down? That's a gamble. And when you gamble in court, the house usually wins. Would you risk trial if you were already staring at decades behind bars?
Case, is that correct? All right, then what I'll do is get your case set for trial. Mr. Dorsey, Mr. Parker has been appointed to you, and he's one of the attorneys who handles a lot of cases for me as a court-appointed attorney. With your permission, I can release him, and I can appoint a new attorney today who could begin preparation for trial a little quicker. Is that okay with you?
Notice how smoothly the judge pivots. No drama, no pressure, just efficiency. When a defendant refuses a plea, the court shifts gears fast. Trial prep begins immediately. Judges like this run tight courtrooms. Time is currency here, and nobody's wasting it.
All right, we'll get that done. Mr. Parker, you're released, and Mr. Dorsey, someone will be appointed today. They should be out to see you very soon to begin preparation for trial. And do y'all know how long the appeal has been pending? Does anyone, do y'all have any idea? Okay. It was out of the other court though, right? Okay. All right. So if y'all get any information on that, if you'll just let me know, it'd be nice to have that potentially by the time we go to trial, but we'll see. All right. Thank you, sir. You can go back with the bailiff.
And I think that Rep Life's hired on that baby career.
Yeah. And you have Patrick Trahan.
It's get evaluated. I will. Yeah. He's one that was normal and just went crazy.
Oh, we need to reset him?
Yes.
Okay, we're going to reset Patrick Trahan for an evaluation. Yes.
On the revocation, it was an interrupted revocation.
Right. Yeah, that's what they said. Thank you. Let's see. Mr. Kimler on Naomi Kidd. So I have that sentencing, but why'd y'all do new paperwork? I don't understand. I mean, he's already pled on 4, 5, 8, 9, and 13.
Okay.
Pled true before, and we got an updated pre-sentence report, and he wants to change his plea.
It's on 4, 5.
What am I on? Naomi Kidd?
Yes.
Okay, well, this is one we have lost our files. I had to get it recreated, so I just have the motion. Was there? It looks like it was an amended motion. Somehow that file got lost.
All right. So
that's
what
fine
we?
If he's already
So previously, Mr. Kidd was in court, entered pleas of true in a motion to revoke or a motion to adjudicate, and pled true to, again, counts 4, 5, 8, 9, and 13. At that time, it was unagreed.
He subsequently received 117 months in the federal system, Your Honor, for each.
Okay. So he has already been sentenced in the federal system to 117 months.
And it consented to this.
Okay.
So that's why we're doing low on the district in this case, Judge.
And that's my court order.
Okay.
I've got a copy, Judge.
So he's on. I understand what y'all are. I understand what y'all are trying to do. However, I don't know that just getting rid of the case is what I think is appropriate. If he's on probation for robbery, placed on probation November 16th of 2022, and has now been sentenced, which means he either pled guilty or a jury found him guilty of new offenses while on this probation of Hobbs Act robbery, brandishing a firearm in a crime of violence, possession of a controlled substance with intent to distribute, and possession of a firearm in furtherance of a drug trafficking crime.
No, I'm not sure the offense dates and all that. They may predate him being placed on probation.
What did you get 117 months on? So the brandishing a firearm in a crime of violence. So brandishing a firearm in the robbery, but they just
It's the same crimes.
so the Hobbs Act robbery and the brandishing a firearm. Okay, and you got 117 months for those. Okay, I want to know offense date.
What was the
Do you have that?
I've got a judgment. It says offense in 2/19/25. I don't know if that means that was the offense date. If that was the date that he pled.
2/19 of 25 is the offense date, but I have him taken into custody on February 25th.
so right?
February of last year is when you did it. But when did you? Okay, so after you were already on this probation. This didn't happen a long time ago before you got this probation. You were on my, I want to make sure, you were on my probation and you committed the new offense. I'm just trying to get the timeline. Correct. Okay. Then I understand how. You started my probation in 2022. My question is, did the new robbery, the federal robbery, happen before 2022? No. Right. Okay. So I understand the moving of the case. He's already pled true to counts 4, 5, 8, 9, and 13. I think with the judgment, obviously, and the state could easily prove up the new, at least part of the new offer.
It is. The judge rejects the 2-year deal. Why? Because probation is a privilege. If you commit the same type of crime while on probation for it, that's a major red flag. This isn't just about punishment. It's about pattern. Judges look at behavior trends. And this trend, not good.
I'm not going to accept an agreement of 2 years. I don't think that is appropriate. I understand that it runs consecutively, but it sounds to me like somebody who's on robbery who commits another robbery needs a little more time. So, 117 months is, yeah.
You want to get an updated pre-sentence
I already
report?
did. I'm ready to send it to them today. I've already got it. I mean, I've already got an updated pre-sentence report. Y'all got a judgment saying he's got 117 months.
I didn't know if the court wanted to know the facts of the underlying federal charges.
If you want to tell me them in
I
a
don't-
hearing today, here's the thing. It's already was unagreed. We're going forward unagreed. I'm deleting this paperwork. Let's go forward. I'll make a decision today on sentencing. And so let's start with Mr. Smith. Well, first, have you both had an opportunity to review that updated report?
I have not, Judge.
You want to?
I
I'll
can
hold the
copy.
case. Go ahead. You good? Okay. Do you, so with regard to counts, let me look and see which count it actually was. It looks like, I mean, hold on. Okay. So it looks like after he pled on when we were here before, he pled on a first amended motion to revoke unadjudicated probation. And since then, another administrative hearing was filed. There is a second amended motion to revoke unadjudicated probation. Let's see what that included that this one did not. For the discussion and testimony today with regard to the fact that he has received 117 months on a federal offense of some combination of either Hobbs Act robbery or brandishing a firearm in a crime of violence, same offense.
He got convicted on both of those. He received 33 months on count 1 and 84 months on count 2. So it was 33 months of brandishing a firearm and 84 months of Hobbs Act robbery.
The firearm case.
And those are running
Those are stacked
stacked.
on top of each other and stacked on top of the state.
Here's where it gets complicated. Federal time is already stacked. 33 months plus 84 months. That's how federal firearm enhancements work. Mandatory consecutive sentencing. And now the state is deciding whether to pile more on top. This is what happens when state and federal systems collide. Different courts, same consequence.
Whatever this is. So they knew over there that this was pending, and that judge already made the decision that this would run consecutively.
I spoke to his defense attorney in the federal system.
Okay.
He said they deviated based on the fact that this case was already pending.
Okay.
The part.
It was taken into consideration in his federal sentence, and they went with the guidelines.
So there was an upward departure because of the case being committed while he was on probation.
Sounds like it. Okay. Mr. Kemmler, you may go forward with argument for sentencing.
Well, Your Honor, I suppose the salient factor here in sentencing is the additional charges that led to him being indicted federally. And it's understandable his reluctance to accept what amounts to the minimum sentence on the state charges because of the 117-month state charges. I suppose I would simply observe it would just determine that there was an upward departure in the sentencing guidelines of the federal system that was predicated on the tendency of these been committing this federal charges while on state probation for these charges. I know the court's probably inclined to go above the 2-year recommendation. The court stated previously, I would simply observe that he already has been somewhat sanctioned in the sentencing determination of the federal system because of the status on probation here in state court, which we are running the second one. And he may have gotten less time federally but for the existence of this probation. So I would just ask the court to consider that and determine what the proper
And strategy shift. They're arguing he's already been punished federally. That a classic mitigation angle. Double impact sentencing. Basically saying, don't hit him twice for the same behavior. Smart move. But the judge has already signaled she's thinking bigger than just numbers.
sentence in this revocation.
Thank you, Mr. Kemmler. Mr. Smith?
Judge, I have quoted from it. I guess I would offer you as a copy, or certified copy of the federal judgment, which would allow the court to then find counts 14 and 15 in the second amended motion true.
Well, we didn't go through the second amended, so let me see. The first amended actually has the robbery.
That includes everything up through 13. So the second amendment was 14, 15, 16, and 17.
I have no objection to be considered, the judge will be considered those things.
Okay. And the first amended actually on count 11.
I believe
The
those were
allegation is-
the state charges, the same thing, not filed with the state, picked up, not offense.
Okay, but it's the same offense,
Same
the robbery,
offenses.
February 19th.
She amended the second time.
Okay.
The same facts.
No objection to states one. All right, it's admitted. Anything else? Argument?
No,
Thoughts?
state leaves it up to you.
So what I'm looking at is that there was also, and can't tell what happened with it. Back in 2024, there was an unlawful carrying of a weapon by a felon. Deferred.
That was the original charge that was alleged in the original administrative hearing.
Okay.
But the filing on it, the subsequent charges are federal.
Gotcha.
That's why.
So there was at least an instance back in March of 2024 where the defendant was arrested and in possession of a firearm, but because he was not convicted, it was not filed. So we had that. Administrative hearing was held. He already had completed both tracks of ISF and a motion was filed. And then he was absconder. And while he was absconding, picked up the new federal charges. Okay. All right. Anything else? Anything else?
Is that accurate? That's it.
Okay. So then at this time, I am going to find, based on the evidence presented today, count 11 true in the first amended, which is the robbery. It's still the same offense, even though it was federal or county. It was committed here in Jefferson County on February 19th of 2025. Everyone's agreed to that. So I am finding count 11 true. And at this time, Mr. Kidd, I'm going to find sufficient evidence based on finding count 11 true, as well as your pleas of true to counts 4, 5, 8, 9, and 13 to find you guilty of the offense of robbery. I'm going to sentence you to a term of 7 years in the institutional division of the Texas Department of Corrections. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. This was not an agreement, so you do have some rights to appeal. I'm going to hand you that certification. If y'all will please sign it, Mr. Kimler, and give him that bottom copy. Also, I'm going to hand you a written admonishment regarding your ineligibility to possess a firearm or ammunition. Because of the judgment entered against you, you're ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. Firearm is a legal term, and you should read the written admonishment I provided you to see what devices qualify as a firearm. If you have any questions about the laws that make you ineligible to possess a firearm or ammunition, or about how long that lasts, you can talk with Mr. Kimler. You need to sign that so you can get a copy of it, saying that you received a copy of that. Thank you. And did you mark this, Philip, please? Thanks. So that would be 2. Yes, states 2, please.
Years. Not 2, not the maximum, but enough to send a message. The judge clearly balanced the federal time with the probation violation and pattern of repeat robbery. This wasn't emotional. It was calculated. And here's the real takeaway. When you're on probation, every decision matters more. One mistake doesn't just reset the clock. It multiplies it.